All right, let's see if we can't get some members here. I know some people are in other committees, but if the sergeants...
I'll present, Madam Chair.
Yeah, we actually have Assemblymember Campos here, and that is file item 10. And let's go ahead and hear that measure. Let's hope we can get additional members here, and we'll go ahead, invite you to present and your witnesses, and then we'll have discussion. Good afternoon.
Good afternoon, Madam Chair and members. I have accepted the amendments suggested by the committee and thank you and your staff for working with my office. AB 538 seeks to protect crime victims and their family members from being re-victimized by limiting the opportunity for criminals to profit from their crimes. Existing law does not effectively protect victims and their surviving loved ones from the commercial exploitation of violent crimes for entertainment purposes. My bill will maintain the current 10-year statute of limitations, that was one of the things that you asked, but will require that the victim or their next of kin be notified when a contractual agreement is made for the sale of the story of the crime committed. Madam Chair, I hope that as we move forward with this, that it passes, and the sole thing that we want to happen in this, and we want it to happen in an effective and timely matter, is to notify the victims and their family that there is discussion or that they may be entering into a contract with a media entity to be able to tell their story. This is notification. It's that simple, but it's very important and very crucial. I now will ask my witnesses to testify.
Thank you very much. First witness.
Thank you, Madam Chair. Members, Dawn Kepke with McHugh Kepke and Associates on behalf of Crime Victims United of California, the sponsor of AB 538, along with some victim members of the Avila family who will share their story. Just briefly, Madam Chair and members, again, this bill is focused on notification that a contract has been entered into for the sale of the story of a crime. And importantly, first and foremost, this is about allowing a victim to be aware that something may be put out in the media in some form or fashion so that a victim and their family can prepare to see their story perhaps portrayed in some fashion. And so that's first and foremost what this is about. Secondarily, as part of current law, the Son of Sam law provides a 10-year window for victims to pursue civil damages through the Civil Code of Procedure to seek damages associated with the sale of such stories. While that is going to remain at a 10-year mark, the challenge is that victims in most cases aren't aware that a contract has even been entered into such that they even could pursue that option that's already current law. So that is secondary to the initial part about preparing themselves, but nonetheless, if a victim doesn't know that a contract exists, how can they utilize that process? In terms of, the actual component of the contract and any ability to veto that, this bill gives no right to the victim to interfere with that contract from being entered into, from that story being told. So to be clear, there is no provision in this bill that does that. There have been some questions and concerns raised around the First Amendment. We do believe that this bill has been narrowly crafted to meet the intermediate scrutiny requirement, such that it meets the state's interest as part of enforcing and upholding Proposition 9, which is the Victims' Bill of Rights, the Marcy Law, which provided for victims to be made whole and be entitled to and receive restitution for the crimes committed against them. So for those reasons, we feel that this, again, was very narrowly crafted, and would also just like to support the comments made in the analysis, which is a very thorough and appreciated analysis about the concerns of the media folks who would feel like this is a chilling of free speech to the extent that they would have to do such notification. The notification is merely a simple FYI, a contract has been entered into. The bill requires nothing more than that, such that the media entity wouldn't even have to indicate who they are, such that the victim, if they feel compelled and want to pursue that civil code process to seek damages, they would have to then in and of themselves hire legal counsel to pursue that route. So for those reasons, we strongly support and believe this is narrowly tailored. Thank you.
Thank you very much. Good afternoon.
Good afternoon. My name is Siobhan Avila, and I'm here to represent the Avila family. My sister-in-law was murdered in 1985. She was 17 years old, a minor at the time. She was murdered by two women, but one that was the mastermind moved in with the family afterwards, served 23 years in prison after being found out, and was released in 2011. Not long after Karen Severson was sentenced to prison, Lorimar production company reached out to us and wanted to do a movie. And we did do a movie called A Killer Among Friends, and it gained a worldwide following. And since then, there's some friends that had started a Facebook page. And it was through the Facebook page that we had found out that our killer had done her first book. It was under an alias name. It was called Hope Beyond the Fences by Kay Crane, which was really Karen Severson. Karen Severson actually reviews her own book, Kay Crane's book. Then shortly after, another person from Tennessee reached out to us and told us they read the book and that it was slanderous and horrible and pretty much re-victimizes Missy all over again. Then shortly after that, we found out via Twitter, via another person on Facebook that let us know that a movie was coming out. And then finally, the third book came out, and it was called My Life, I Lived It by Karen Severson. This time she used her real name, and she released it on the anniversary of the murder. This has been a direct victimization and attack on our family. She has been attacking our family directly for years. The notification is just a minor process for what we're going to have to go through. We've had to file a civil lawsuit. We filed it in March, and we still haven't been able to serve her. We contacted the parole board. They said they couldn't help us. We can't track her down, but she was given our address and knows where we live so that she can live within 35 miles away. But she did get a PR team that supported her, and her PR team was right down the street from us, literally on the same street as us. So we have had to hire security. We've spent an enormous amount of money that we'll never get back. But we don't want this to happen to anyone else. We don't want anyone to be victimized like this. This is truly a nightmare that we wish on no one. And this bill, moving forward, we would be very, very grateful.
Thank you very much. Appreciate your testimony, and apologies. The system is certainly not perfect. Thank you.
Thank you.
Other witnesses in support, very briefly, please. We've let you go over, but we'd like to just make it very brief, please.
I'll thank you for allowing me to speak on the committee. It's almost been 30 years since my sister was murdered. This keeps happening. We can't let this happen to another family. Please, thank you.
Thank you very much, sir.
Madam Chair, members, Aaron McGuire on behalf of the California State Sheriff's Association, also in support.
Thank you. Other witnesses in support, if you'd step up, name. Again, this is a notification bill. Please.
My name is Lacey Matters, and I'm from Los Angeles, and I agree that crime shouldn't pay. I support this bill.
Thank you very much. Other witnesses in support?
My name is Anthony Avila. I'm a resident of California, and I support this bill.
Thank you very much. Other witnesses in support? Are there witnesses in opposition? If they come forward, please. Let's try to, we have a couple chairs here. Good afternoon.
Good afternoon.
Again, 2 minutes each, please.
Yes. Chairwoman Jackson, good afternoon, members of the committee. My name is Melissa Patak. I am here on behalf of the Motion Picture Association of America and our member companies, Fox, Disney, NBC Universal, Paramount, Sony Pictures, and Warner Brothers, to explain our opposition to Section 2 of AB 538, which, as I understand now, is all that's left of the bill. Is that correct? Essentially.
There is a small provision in Section 1, but basically, yes, it is
This is all
Section
that's left of the bill. Okay. At the outset, please understand, we want the committee to understand that MPAA and our member companies respect that California law emphasizes the importance of restitution for victims and rights of victims in the aftermath of the terrible tragedies that have befallen them and their families. However, we believe that Section 2 violates the First Amendment because it singles out and burdens protected speech. The bill requires the reporting of a contract for story rights, which is unambiguously speech. The purpose for reporting such a contract is for the state to notify the victim that the felon has earned money, but not any money, only that money which comes from First Amendment speech, so that the victim can bring a civil suit for restitution. This is squarely within the U.S. Supreme Court's decision in Simon & Schuster, as well as the California Supreme Court's decision in Keenan, both of which are very well explained in the committee's analysis. Section 2 will also act as a prior restraint and have a chilling effect, as also noted in the analysis. What if an offender's story, as told through the media, brings new evidence to light and the courts take another look at the case? I know this may sound hypothetical, but it's exactly what's happening in the state of Maryland because of NPR's podcast, Serial, about the murder conviction of Adnan Syed, which has captivated a national audience. What if an offender can write to tell his story of rehabilitation or redemption and to warn others about the dangers of the path of crime? Again, sounds hypothetical, but former gang leader Stanley Tukey Williams did that in 9 books that he has written. This bill puts stories like these at risk of never getting told. And there are many others, from Eldridge Cleaver's Soul on Ice to the story of Malcolm X to Catch Me If You Can by Frank Abagnale. The state's interest in restitution for victims is clearly very important, even under a lesser standard of strict scrutiny. And we believe, as the analysis really notes, that this would be analyzed under strict scrutiny. But even under an intermediate scrutiny, there is a very strong likelihood that AB 538 would be found to be unconstitutional because there are less restrictive means to provide information to victims. Penal Code Section 1202.4 could be amended to require a felon to provide periodic notification of financial information even after he or she is discharged from prison and parole. This puts the responsibility on the felon and would cover all income and earnings, which is really important and not singling out just speech, such as inheritance or wages or other ways a felon might exploit the crime, as noted in Keenan, including memorabilia and personal effects.
Thank you.
The proponents, I have one other point, I'm sorry,
please.
Madam Chairman. The proponents of the bill have indicated their motivation for the bill is more than restitution and that it is about the ability to have advance notice that a crime story will be retold. However, in this day of self-publishing for books and YouTube for videos, an offender can put the story out there without any contract and without any compensation. So in addition to the constitutional challenges, as a practical matter, this bill is unlikely to achieve its objective.
Thank you. Thank you.
Thank you.
And with that, you're asking for a no vote. Next.
Thank you, Madam Chair. Mark Powers with the California Broadcasters Association, the local radio and TV stations. This would be a rare occurrence for a radio or TV station, but it's a unique administrative burden, we believe, and it's also not a simple burden, simply because it applies to specified offenses, specific felons, and even then there's exceptions to it. It also has some ambiguity to it. If an inmate gets paid for telling the story of a prison break and in it mentions their crime, does that mean that the storyteller has entered into one of these contracts even though it was the intention of the prison break being the story and not the crime? And so what we're worried about is a media entity may really avoid these type of stories in fear of inadvertently committing or being accused of committing a criminal act simply by using a criminal to help tell a particular story. And so this one-size-fits-all approach to contracts really doesn't recognize the huge difference between the size and the scope of a small talk show appearance fee negotiated a few hours before broadcast and a major book deal under development for several years. You know, if the rationale for this bill is that it provides victims and their families time to emotionally prepare for mass media stories, it seems the potential damages to a station that they would face for a $100 talk show interview fee that was going to happen in 3 hours, that there would not be notice to victims because the victim services has 90 days. So most of our contracts would be, you know, executed before that time. So we're worried about the litigation costs, we're worried about the penalties for non-disclosure, and we would urge no vote.
Thank you very much. Other witnesses in opposition? All right, we'll open it for discussion. I first want to make an observation. When I first read this bill, I was kind of curious as to why it had been brought. I remember the Son of Sam, and I was shocked to learn that it had actually not withstood constitutional muster. To me, the notion that someone who commits a heinous crime, and in that instance, I remember New York City being absolutely terrorized by this man, that we were still willing to provide First Amendment rights to convicted murderers. We don't let them vote, but I guess they still have their First Amendment rights. My challenge here is I would support a Son of Sam bill, which would, of course, be even more restrictive than this. But being that the Supreme Court found that again, it's a First Amendment issue, I think, and I appreciate your attempting to do something to recognize that crime victims shouldn't be re-victimized over and over again. And certainly when people tell their story and they make money at it, to boot, even though there is restitution, you know, then you're in a battle of what does that mean? And there's a point at which it would be great to be able to try to get on with your lives. That being said, I'm not sure that you know, those arguments aren't compelling. I think this may very well be something that needs to make its way through the courts again. You may be 100% right. On the other hand, this may be an instance where there is some, that this is deemed to be sufficient notification. So I am not the Supreme Court, nor would I ever want to be, actually, come to think of it. But I just, I thank you for trying to do this. I just don't know whether or not this will pass muster, but I don't feel like I'm in a position to make that call at the moment. And as much as I appreciate all sides of this issue, and I know Senator Hertzberg, who would love to be on the Supreme Court, is going to ask a couple questions to try to resolve all that.
You know, the Chair and I have talked about this a little bit. Senator Campos and I don't know, you know, the strict scrutiny standard is pretty tough. This is a very, very difficult situation. I was shocked to learn that the Son of Sam case was overturned. I didn't realize that in terms of how this, I just thought that was the law and that this was simply adding another layer to the law. But, you know, the question is, and it certainly doesn't apply to what the Motion Picture Association was saying, is what if people self-publish? But you do have contracts all the time where, this was raised to me and I thought it was a compelling argument, where someone says, let's go investigate that. Here's some X number of dollars to go and take a look at this idea, right? And the idea never goes anywhere. I'm just concerned about the chilling effect this has on the creative process. Certainly the end goal in terms of the grief and heartache that happens is a legitimate concern. I don't have a quarrel. But what if someone goes and says, let's write a treatment on a book and let's look at it, and it goes up the ladder and people say, nope, ain't working. We're not going to do that, right? It's not appropriate. Or even often in the movie business, all the time there's stuff where a lot of money's spent and contracts are hired and people are flown to interview witnesses, and they say, you know, they come back to the producer or to the motion picture company and they say, you know what, we shouldn't do this. Or some higher executive says, you know what, we're not going to do it. The delta between the strict scrutiny of actually knowing that someone looked at the idea on the one hand versus actually green-lighted a project. The book's going to be published. You should be notified. The movie's going to be made. It's gone through the end game and it's been green-lighted at a motion picture studio. You should be notified. But the early process, the question becomes, when you have a strict scrutiny standard and you want to protect this creative process, do you want to have that chilling effect on that process? And, you know, from my point of view, I don't know in this high-tech society how it extends to self-publishing or to the or even the question that was raised, which I didn't think about with respect to broadcasting. Somebody signs a contract 2 minutes before. But certainly, and I don't know, I wouldn't know how to draft this, quite frankly, off the top of my head. But I do think the narrowing of it still doesn't in any way invade the underlying purpose that you're trying to achieve by making this law, against balancing that of a creative process. Because if someone tries and doesn't do it, why is there harm there? I don't you think about that, Madam Speaker Pro Tem, for life. I put that out there again to just in the, this is a committee hearing and we talk about ideas, and I just thought about it over the weekend.
Well, first of all, I appreciate your thought in addressing this over the weekend, and it tells me that
We're thinking about you.
This really did strike something in you when you thought about this. I believe in the creative process as well, but I also believe that when we're talking about individuals, I mean, I was thinking about this as well as you were thinking about this on the weekend about this family, this extraordinary family. I mean, the courage to have already gone through 3 committees and continue to talk about what happened in their family, so that Missy Avila's death and the situation was not in vain, and then no other family will have to go through this again. The challenge, so you thought about that, I think about this as well. It is my responsibility that is, as a policymaker, and I heard Senator Jackson and Senator Hertzberg, I hear what you're talking about. But if we don't attempt to try to at least protect the family that continues to be re-victimized, and if it goes through the court, then I think that's a win as well, because then we will know, we will know whether the Supreme Court or whatever court looks at this, they will look at it in a different manner than the lens that I'm looking at it, and maybe the lens that you're looking at it, and maybe we will get the result that we want. But if we don't attempt this, then I think we are doing a disservice to not only the Avila family, but I think to families throughout the state of California. And then the other question that you asked, the language about whether it goes up to the ladder and then it doesn't go anywhere. The language is a little vague around there, but I'm going to let Dawn kind of address that. If I need to tighten that language up, I'm more than happy. But I'll let Dawn answer that question.
Yeah, can I just, before Dawn can come on that?
Please.
I just want to I just think it's important, you know, unfortunately, I spent a lot of years of my life as a lawyer. And I don't like reading court cases that diminish the integrity and the elegance of the legislative process. And so it seems to me when you're dealing in areas as politically sensitive on the one hand and as constitutionally sensitive as the First Amendment, even if someone challenges this who goes out and does a self-publishing or challenges this, at least what I don't like reading is these court cases that just stick a finger in the eye in the legislative branch that says we just ran roughshod of the First Amendment. So whether this falls by the way of the Son of Sam case through litigation in the future, at least I want to stand tall as someone who sat on this Judiciary Committee and tightened that language so that this creative process and these kinds of arguments are at least somehow protected. So I just would recommend as you move this forward into appropriations that you do that.
Right, and then if we have to tighten the language, I'm more than happy to look at tightening that language.
So, please, if you'd answer very briefly, and then we're going to, Senator Morlock has a couple questions, and we've got to get on to the next.
Understood, Madam Chair, thank you. So with regard to the Son of Sam law, it's specifically about a criminal not profiting from the sale of their crime. So from, you know, from our vantage point, to the extent that there are resources exchanged, that's important for the purpose of this bill. To the extent that it has an effect on chilling of speech, we would argue that because no details are required to be divulged as part of this, just mere notification, it would be incumbent upon the victim to actually pursue further detail and finding out if there is a path forward in terms of, seeking damages. So, although they're related in terms of overarching principle around a criminal not profiting from their crime, at the same time, we want, that process on the civil side to be able to play out to the extent that a victim even chooses to move forward with that. But we really feel like this is narrowly tailored such that we didn't require specific pieces of information regarding that contract to be put in here such that it wouldn't violate that particular provision.
Thank you. And if this will be going to appropriations, I believe, if it does pass through, and if you would continue working on that. And then there's the other side of the issue of whether it has a chilling effect. And I do think that this may be something that needs to get further honed in with the court's assistance. We'll see what happens. Senator Morlock. Sir.
Thank you, Madam Chair. Assemblywoman Campos, this is a righteous bill. These are really interesting times where you would have an admitted murderer who's able to write. It's quite astounding, but it's also a historical event. It's something that happened, and it will always come up. And I am amazed. I was part of a historical event in Orange County, and just the other day I Googled books again. I found them in another dozen books. No one told me I was going to be in the book, and I didn't get any benefit financially, but we're in a whole new age where this stuff comes up, but it seems to me that there should be some kind of etiquette in the industry. So what do other states do? And then maybe I could ask the industry, what do you do out of just maybe proper etiquette to inform impacted people that you're going to be in a book or a movie? So I'm just curious what the industry standard is.
Well, that may be a question for the industry to be able to answer what their industry standard is and their etiquette.
One second. Let's see. Is there a response? What would the industry?
Right. I think the answer is, and I'm not saying this just because I'm a lawyer. It depends. I mean, it just depends
like
on what the situation, what the story is, who's involved. It just really depends. And you're sort of traversing into the area that we call right of publicity. You have the right to control your image for commercial exploitation, but there's recognized not only in California law, but beyond in the common law and courts that there's a First Amendment exemption for the use of your name in a book or something like that. So again, these are complex issues. I'm happy to talk further about it, but I think in the interest of time, so the short answer is there isn't a quote-unquote industry standard or etiquette.
So if we, any other?
Well, Mr. Avila was going to answer. I'd like to hear what.
Yes, I'd just like to add, I'm the executive vice president of one of the largest television reality companies. So there is an etiquette. It's common decency that we do shows that affect people's lives. We are going to make sure that they know. And we're going to make sure that everybody knows. And if it goes down a road that we're going to portray a murderer and the family objects, it's the cost of doing business and we probably won't do it. So there is some decent producers out there. Just want to let you know. Thank you. Well, that's good news. Glad to hear that. Thank you. We'll wait for a quorum if you'd like to close it. We could spend the rest of the afternoon on this, and I think would still be interested. And I appreciate everyone's participation. I appreciate the author for bringing this bill. I think this is an issue that really deserves to have sort of a full discussion in the court system. And to the extent we can craft it narrowly, keeping in mind the First Amendment, they're very high. It's a high bar. But I can't believe we can't craft something so that victims are also recognized in the process, and look forward to continuing working with you. If you'd like to make a brief close.
Well, Madam Chair, I think in working with you, went through the Assembly and it came over here, I think working with you and your staff, we've narrowed it tremendously. And if we need to continue to work for it per your request, I'm more than happy to look at it. But I think it's important that we move it out of your house and that it gets the opportunity to be able to get to the governor's desk, to get signed and put into law so that we are not creating space for families to continue to be re-victimized.
So that for clarification purposes, when we do get a quorum, we'll have a motion. You are
So I
taking...
respectfully ask for an aye.
Thank you. So you will be taking all the amendments, including the clarifying amendments that were on page 15?
Yes.
Very good. Thank you very much. Appreciate all of you being here, and we will keep the discussion going. And condolences continued to you and your family.